Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
All right, welcome back to another episode of Just Verdicts. And today, joining us is Doug Olcott from Edgar Snyder and Associates. How you doing, Doug?
I'm doing great, Brendan. How are you?
I'm well. And as is becoming a common refrain for me at the start of these things, thank you for putting up with my personal tech issues. It's microphones. It's always something. I don't know what I do. I sprinkle some sort of like malfunction dust on my computer right before these interviews start. But I appreciate you bearing with me, and it's good to be here with you, man. I mean,
it's good to see you.
Yeah, I mean, I have not known of your great trial abilities and trial outcomes, for a long time now. Back when you were at Dallas's office, and you've been at Edgar Snyder Associates for a while now. But I was thinking to myself in lead up to talk about this verdict that you got in the Laura Ryan case, that you're a little bit of a mystery man in your, like, the prior history of Doug Olcott. I mean, I know, you've gotten tons of mega verdicts over the years, but are you from New Jersey originally, or was that where you went to law school?
Yeah, no. I grew up in a town called West Orange, New Jersey, which is in Essex County, which is where Newark is, So I grew up, went to college at Montclair State College, then went to Seton Hall University Law School, and I originally started out practicing as a defense attorney, spent my first 15 years as a defense attorney, worked house counsel for a period of time for State Farm, did defense work for, private firms, and in New Jersey, I think you may be aware, they had a program where you could become a certified civil trial attorney by the Supreme Court of New Jersey, so I went through that whole process, did that. When I was a defense attorney, I went out to Chicago for the Defense Research Institute. So I think my background, having done defense work for 15 years and having done all those things, I really think it's a leg up now being a plaintiff's attorney, because I think I have a better understanding as to what the defendants are going to do, and then being able to anticipate how they're going to approach a game, because quite frankly, in my 35 years doing this, not a lot has changed on the defense bar side, if you know what I mean, of how they approach cases.
Well, I mean, tell me about that. I mean, I think that's really interesting. I've just by total chance, fell into plaintiff's work out of law school. And so I've never worked on the defense side, and I'm always intrigued by, an attorney like yourself who, worked so heavily on the side that opposes us so much. And yeah, I mean, if you could help me understand a little bit better, sort of, what is the defense playbook, or what is the focus in cases that you think kind of, you have that insight on now that you're on the plaintiff side?
Well, when I started out back in 1990, it was a lot different because, I felt like we worked more with the defense carriers, if you know what I mean. Then there came a time when things shifted, when being a defense attorney, you were fighting two fronts. You were fighting the plaintiffs, and you were fighting your clients, the carriers, because they're questioning, what you're doing, your bills, slashing bills, and it became somewhat disheartening that you're just trying to represent your clients and do a good job. And like I said, being told, well, you can't do this or don't do this. We're going to start sending out, subpoenas. We're going to get this, and it really became somewhat formulaic in terms of, you get an assignment from a defense carrier, you do your initial evaluation report, you're going to file your answer. In New Jersey, we don't have preliminary objections and all that stuff. But even out here now, you get your preliminary objections. They're going to file their answer. It's just a routine. It's okay. Now we serve interrogatories. Now we take depositions. Subpoenas get issued. We send for an IMA, and then, once we've done all the things we can bill on a file, then we start talking about, hey, how about we go to mediation? So it's just, I got kind of tired of doing that, and having to give reports and all that stuff. So I had an opportunity, believe it or not. I was a defense attorney, and I got hit for a $2 million verdict. Okay. Thankfully, the carrier had $2 million. The carrier was there during the trial. And again, this was out in New Jersey. But fortunately for me, the plaintiff's attorney is like, "You're supposed to be house counsel. Like, you were such a pain in the ass. Come work for me." So I did.
So they were so impressed working with you, even though they got the verdict, that they wanted you to come over to the plaintiff's side.
So for again, example, in New Jersey, it's more like the federal court. So like we do expert discovery. And it was a really kind of unique case where this girl had fallen on steps, and when she was falling, she pulled her baby close to her face, and she ended up smashing her nose, broke her nose, and ended up losing hearing in her one ear. And the treating doctor for the plaintiff wouldn't provide a report, so they hired an IME doctor, and we deposed doctors for trial back in New Jersey, and I had a lot of fun with him. And plaintiff's counsel realized like he was going to lose at trial. This expert was so bad, so he was ultimately able to get the treating doctor to testify on his behalf. And like I said, things worked out well for him. My IME doctor conceded something, and it went against me, but it was a hard fought thing. And if you try enough of these cases, you're not going to win them all. But if you put in a good fight, that's all you can try and do, and hope for the best with the jurors.
Doug, from your perspective, on the insurance defense side, and we'll stick with sort of general liability because I think
Sure.
the medical negligence, is probably a little bit different. I mean, a lot of similarities, but
Yeah.
perpetually. I mean, I've been doing this about 20 years now, and even though we do predominantly medical negligence, we handle a fair amount of different types of general liability cases, and oftentimes I'm very surprised by how the insurance company was analyzing or looking at a case compared to sort of how I was viewing it.
Mm-hmm.
And sometimes I feel like they way overvalue a case that I think is pretty weak, and sometimes they'll undervalue or see the case substantially different than I do. Do you see what I'm saying? And I think I'm missing, like, what are the big factors on the insurance defense side that drives whether they think, oh, this is a crappy case or highly defensible, or this is one we really need to flag and try to settle.
Well, again, it's been a while since I've done defense work, but I think they have certain themes in terms of the types of cases. Closed head injuries. If you don't have that objective, brain bleed or something like that, they think it's all just hocus pocus, so to speak. Your client's just a malinger. They're making it up. The standard miss type of cases. There's not really a lot of property damage, so they think your client, as the plaintiff, is just looking for a payday and all that stuff. I think there's so many what I'm going to call institutional biases built in, and I think, and a lot of it I think holds true in the case that we're here to talk about. Is I think the defendants, they find one or two things that kind of fit their narrative, and they hang their hat on it, and they almost get this myopic view of, well, I'm just going to pound these 2 or 3 points that work in my favor, and I think they don't really look for the boogeyman. I don't know about you, Brendan. I mean, I know you're fantastic as well, so I'm going to assume I spend all my time worrying about the boogeyman. What is the little thing that's going to hurt me? What is the thing that, I know the strengths of my cases. It's like, but I'm not worried about my strengths. What do I need to worry about? And how do you look at your case critically to say, okay, if this comes out, or how am I going to deal with this issue? And I just think that's what makes you, or what I'm going to say, me, or any other plaintiff's attorney who ends up getting a successful verdict. It's staying up late at night trying to figure out what are the weaknesses and how do I address them. And I just think in my experience, having both done defense work and when I've been successful against defendants, it seems that they just get caught up on one or two issues that they think are going to carry the day. And they just figure they're going to talk over whatever weaknesses they have. It's like, if we say it enough times, people repeat it, and believe it.
I couldn't agree with you more. And I think there's like two sort of like complementary issues, like concepts with that. So one is, and I'm sure you've had this experience many, many times, and maybe you had it in the Laura Ryan case, where you get to trial, and because the defense, or the adjuster behind the defense lawyer has that myopic view, that it's almost shocking how much they seem to be just not even acknowledging what you know to be some strong issues on your side. And it's almost like you're in the twilight zone sometimes. Like, am I completely miscalculating what I think is good for me? Because they seem to just like act as though it's either not there or whatever. And so I think that can be very helpful to us because it's maybe a misassessment of the risk, a misassessment of like the real appreciation of the nuances of the case, which can help us get verdicts, but sometimes makes it difficult to settle cases.
Right.
On the flip side, sometimes that can be a good thing because they doggedly stay on their case. And I think sometimes as plaintiff lawyers, I do the same thing, Doug. What keeps me up at night are all the potential landmines and what am I missing and what haven't I thought of, and trying to turn those things as much into my favor or they kind of work into our, to the benefit of the case or the story of the case as much as possible. But I think sometimes we can fall victim to making the case too much about the defense issues. And that's problematic. We get off topic of like what our case is about. So I think it's kind of a two-sided issue there. But I agree that I think it's that sort of myopic view. They get entrenched on certain issues. And that's why we wind up having to try some cases and get really good verdicts sometimes. In addition, obviously we're such amazing trial lawyers, but a lot of times it's just the facts were misappreciated by the other side. I think oftentimes what happens when we get these verdicts.
Well, I agree with a lot of what you said there. And I think, and listen, there's a lot of good defense attorneys out there. I don't want somebody to think I'm bashing on defense attorneys. What I think is one of the things with defense attorneys, though, is their clients, because of the institutionalization, they kind of have to do certain things, if you know what I mean. I think as a plaintiff's attorney, if you have a good working relationship with your client, which if you're going to trial, I would suggest you better have, because I don't know about you, Brendan, but I'd take a mediocre case with a great plaintiff any day over a great liability case with an unlikable plaintiff.
Yeah.
My experience is
maybe
somebody who's likable and we can roll with the punches and we can become inventive and work with things. But, I've had trials, and I had a trial in Beaver County where I got a 7-figure verdict before Judge Kutzelman years ago. And the defense attorney, one of the injuries my client had was a back injury, and he also had a shoulder injury. And at trial, I was like, look, we got issues. My guy had been at a chiropractor the Friday night before the Monday morning accident complaining of 9 out of 10 pain. And then we get involved in a car accident. I was like, if we can't convince the jury of your neck injury, we're never going to convince them of a shoulder injury, right? So I got my client to agree we're not going to pursue that at trial. But the defense counsel had already had an IME done of his shoulder. The defense counsel, there's no way the carrier was going to let them not play that doctor's IME at trial. And the jury sat there for an hour listening to an IME doctor talk about my client's shoulder injury. And in my closing, I said, ladies and gentlemen, basically kind of just shows you to the extent to which these defendants will not take responsibility or own up to what they did wrong. They made you listen to a doctor's deposition for an hour for an injury we're not even making a claim for, And again, I don't think it was the attorney was a bad attorney. I think she unfortunately couldn't convince a carrier because the carrier's like, well, we paid for that, that we've got to do that. And so to your point, I think when the defendants have their kind of case set because they're getting a lot of pressure from carriers, they don't have the ability to kind of change strategy midstream, see that maybe something's not working, maybe we should abandon this defense, maybe we should go in this direction. And I think as plaintiffs, we can be more reactionary. And I think to be successful, you have to be, Look, not all our theories, at least not mine, ever work, but you got to figure out what's working, not what's not working. And if the defendant's giving you something, maybe you didn't realize what a good gift it was, adjust your case so you could take advantage of what they're trying to sell to a jury. To me, one of the biggest things in getting a good verdict is using the defendant against themselves, whether it's things that their clients are saying, things that their defense attorney is making promises they can't keep. You walk into the courtroom, we're the ambulance chasers, right? The juries don't want to award our clients money. I think a big part of what we have to do is to establish that we are the people there who are trying to shed, some truth, some light, provide them with facts and let them make their own decisions. Whereas I think a lot of times the way the defense is set up, it's really just trying to ram things down jurors' throats. And they kind of force the juror, you either have to accept what I tell you or not. Whereas as a plaintiff, I want to sit there and say, hey, here are some options. Here are things to think about. Does this make sense to you?
Doug, when you're in trial, in addition to you come into trial, you have a particular theory, and you have your idea of how you're going to frame the case to the jury, your order of proof. But when you're in there, are you, and obviously, who knows what's going to happen at trial, but are you looking for, whether they're gifts or things the defense is doing, either procedurally or through testimony or through misstatements, that you can kind of weave in, to capitalize on kind of the credibility battle?
Yeah, absolutely. It's one of the big things is seeing what are they trying to advance, and where can you catch them with things. Like with the Laura Ryan trial, one of the big things was them talking about, policies and procedures and what they thought they were going to show. And when I think defense counsel right before trial realized that they had problems with their case, they wanted to try and amend their pretrial report to bring in some additional witnesses. And so one of the first things I did in the trial after, it was time for us to present our cases, I got up and I told the jury, look, ladies and gentlemen, I told you in my opening that when we come to court here, we do a lot of work to get ready to try and be able to present our case to you in an efficient manner. I said, and one of the things we do is we serve interrogatories, and this is to find out what information the other side has. I said, and I'm going to spend the next 15 minutes, and it's going to be boring, but I think you'll understand why I'm doing it as this case progresses. And I sat there, Brendan, and I read their answers to interrogatories for who they listed as witnesses with relevant information. I read their answers to interrogatories where they stated, like, this was the policy and procedure book. I read the answer to interrogatory that talked about that there were no other documents. And I did that because I knew at trial they were going to start trying to call different witnesses and all that stuff. And my theory was, by putting it out there right from the start that, hey, this incident occurred in 2022. Discovery was answered in 2023, 2024. Here are the witnesses, here are the documents. And here we are in September of 2025, and they're suddenly going to try and provide different information to you. And it kind of forced them to not be able to do that because they would have looked horrible. And then during the trial, and I'm sorry if I'm deviating a little bit.
This is great.
One of the issues in the trial was the defendants started trying to offer, well, listen, this snow tubing park had been open for 3 prior runs before your client got injured. We've been working Hidden Valley for how many years, and we've never had somebody, go over the back and suffer a T12 fracture like my client did. And they were basically trying to make a Spina argument, and we objected, that there was no foundation. They couldn't show that it was similar events, similar circumstances. But, I'm trying a case against Hidden Valley in Somerset County, where they're the largest employer, and the judge is trying to do everything in his power, legally to make my case go away. So when defense counsel's in questioning, because there's no evidence, but he's questioning about, we had hours of this and thousands of runs and blah, 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 blah. I went back when one of their witnesses was on the stand, and I read the interrogatory that said, provide us with any and all incident reports, blah, 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 to try and establish that. And thankfully, you get the typical lawyer answer, objection, irrelevant, attorney-client privilege, work product, blah, blah, blah. And so I read that to the jury. And in my closing, I said, ladies and gentlemen, the counsel stands here for the last 4 days telling you about all these incidents that never happened, this, that, and the other thing, numbers. I said, when we asked to be prepared to come in front of you, I said, what was their answer? Lawyer answers, objections. It's you're not entitled to it, but I'm going to stand here in front of you at trial and start spouting all these numbers that when the plaintiff asked for us 2 years ago, we told them they couldn't have it. And I think the jury got it, if you know what I mean.
No, I think that is such a compelling argument, and I think I think that's something that a lot of younger lawyers, whether it's don't think to do or they're sort of like, oh, can I do that kind of thing, where I well, there was an objection placed, and what does that mean? And there's a really good CLE on trial guides by Joe Freed right now, and one of the things
He's a good guy.
He's awesome, and it's a great seminar, and one of the many things he talks about, which is exactly what you just did, is he's like, a lot of the knee-jerk reaction by attorneys sometimes is, any of the bad stuff or the procedural crap or the headaches that, all the tricks that they're pulling on the other side, we're thinking about ways to, eliminate it out and block it out. And he's like, a lot of times those things are huge gifts to you that you should be thinking, well, that's the kind of stuff that could really actually tick a jury off that I can
Right.
bring into court. So, when you're getting those, terrible, just boilerplate responses to obvious statements in your complaint, when you're getting objections and not going to produce anything in response to basic discovery requests, and later they're, oh, well, here's that incident report. I think that is the stuff that really can tick juries off with gamesmanship and the games that lawyers play, and can really help us in the credibility battle. And you're just pointing out, okay, that was the way that you chose to operate procedurally, but this can come back to hurt you.
Right.
And here's how. So I think that's a really cool way to have brought that up. And to go back, why don't we skip right to, giving us a summary of the case?
Again, our client was a 39-year-old mother. She went to Hidden Valley for a birthday party that was being hosted by another family for young teens. I think my client's kids were like 9 and 12. The host family had 2 children. So my client's son played football with their son. My client's daughter cheerleaded and danced with their daughter. And there were about 10 or so families that were invited for the 5 o'clock snow tubing event over at Hidden Valley. So they all show up. The family hosting the party had paid for everybody's tickets, but when everybody got there, they had to go into the lodge. In the lodge, everybody starts, getting their kids dressed, getting ready to go. There were the standard waivers you would expect when you're involved in a recreational activity. Most of the moms ended up signing all the waivers on behalf of their husbands and their kids and all that stuff. And then they go outside, they grab their tubes as they're walking to go over towards where the conveyor belt is to take you up the tubing hill. There's this sign of guidelines of 17 guidelines that this guy goes over with them, and then they begin the run. Our client is within the first 15 minutes. She's one of the first runs down. She goes down on her tube. She's seated. As she's going down the hill, her tube rotates, so now she's looking up the hill. At the bottom of the hill, there's what they call the runout area where you're supposed to scrub off some speed, and then there's an embankment, and the embankment is basically a reverse slope, kind of like a ski jump, if you will. The idea is if you go past the runout area that you're going to go up the hill and you'll scrub off enough speed and then kind of glide back down into the runoff area backwards. Okay, no harm, no foul. There are deceleration mats, which really are nothing more than thick rubber kitchen mats that you might find in any restaurant or something like that, that the workers stand on for anti-fatigue, which you put in these runout areas because when the bottom of the rubber tube hits that, it slows it down in case you're going fast. Because let's face it, an inner tube is an inner tube. There's no steering, there's no brakes, and physics is physics. The bigger or the heavier you are, the farther you're going to go and the greater speed you're going to potentially develop. So when my client goes down, there's no workers scheduled at the base of the hill. There's no deceleration mats. And at the top of this runout area, they don't have any type of fencing or any barrier to prevent you from going off. So our client basically gets launched off the back of this thing, like an eagle going off a ski jump. And the back of this is all just where they push off all the ice when they groom the hill in this thing. So there's these large chunks of ice. It was described by some of the witnesses like a moonscape with craters of these big chunks of ice. And when my client goes flying off the tube, she becomes separated from her tube and she comes crashing down on the ice on the back. And that's where she suffered a fracture to her pelvis. She suffered a T12 burst fracture, and she had some lesser fractures in her upper thoracic and cervical area. That was the event that caused her to be injured. She was taken from, Hidden Valley to Somerset Hospital. Once they did the scanning and saw that she had a burst thoracic fracture, she was then immediately transported to UPMC Presby, I believe, where she underwent, placement of 2 rods across 5 levels of her thoracic spine. The pelvic fracture, rest, don't put any weight on it and all that stuff. And again, she had a like a T2 and a C7 pedicle fractures, so they didn't do much for them, but they were there and all. So she was out of work for a period of over 4 months. She was a pediatric ICU nurse at UPMC Children's. So she missed work and all that stuff. When she returned to work, she indicated she could do her job, but it's a pretty big area. So she was fortunate enough to find a different type of nursing job closer to home that didn't require her to be on her feet all day, So those were the injuries. Now, the defendant, we sued Hidden Valley, their corporate entities, VRSS Holdings LLC and VRPA Holdings Inc. That's who owns the land and then who runs the park. But
Was that Vail Resorts?
well, it's Hidden Valley, but our incident was post the nutting. So yes, they're owned by Vail Resorts, but for purpose of trial, they were just referred to as Hidden Valley, So we asserted claims of negligence, gross negligence, and recklessness. The defendants filed a summary judgment motion on the waiver claim saying, hey, you can't sue us for negligence. And, the court granted summary judgment, but said, in accordance with, I think it's the Trayer case, you can't sign a waiver for reckless conduct, So we then made a decision strategically. We got the client to agree to dismiss the gross negligence claims because our thought was, obviously under the law, there's no comparative negligence for recklessness. The Comparative Negligence Act only talks about comparing the negligence of parties, not the reckless conduct of parties. The defendants still pursued, and the judge, much to our disappointment, although how things kind of work out in the end, still tried to pursue a claim for assumption of risk, saying that they tried to say my client shouldn't have been seated on the tube, that she didn't drag her feet, that she had been instructed to based on those guidelines and all that stuff. So we had a big hurdle in that we had to prove reckless conduct, which is not an easy thing, as you well know.
And tell us what what is the burden of proof in reckless conduct
the
cases?
burden of proof, it doesn't necessarily change the burden per se. It's a higher burden, but you have to show, somebody did something either intentionally or with reckless disregard for, the known element of somebody being put at risk. So here we tried to establish that, and we were successful in establishing that with a couple things. One, we used their own policies and procedures against them, and then the lack of policies and procedures. So like I told you, when I read that interrogatory, they had identified their standard operating procedures, okay? Nowhere in their standard operating procedures did they talk about any type of barrier at the end of that embankment. So that was something that we were able to get our expert to talk about. In their standard operating procedures, they talk about how important it is for the people who are positioned at the top of the hill who release the people down to make sure the lanes are cleared, the people aren't, trying to get from one lane to exit to the other. But they're also supposed to have people at the bottom of the hill to help people. Now, one of the disputes was, from the corporate point of view from Hidden Valley, their argument is those people at the bottom are not there to stop guests. They're just simply there to help direct guests to exit once they come down and all that stuff. But as you can imagine, with a lot of corporate claims, the corporate people say one thing, the actual workers say another thing. So we had a couple workers who basically testified that they grabbed tubes. And grabbing tubes basically means if somebody's coming down and they're going too fast, you physically grab the tube to prevent them from going up that. So right off the bat, we had a nice little kind of dichotomy in that the workers are saying one thing and management saying, no, that's not what you do.
How did you frame it in opening? The overall theory of what they did wrong and why it was reckless.
Well, we talked about the fact that, our three main points were the following, if I may. It was that, there should have been people at the bottom of the hill to grab these tubes and nobody was positioned there. The second thing was the deceleration mats were not put out at the time, but immediately after our client's injury, they were put out. Now, the judge wouldn't allow us to offer that because he said that was, subsequent remedial measures. We argued and we provided case law that said it's not. And it's not a remedial measure when that's your standard operating procedures. You just didn't do it. That's the evidence of your recklessness. But the judge took a different view. And then our third thing was that you didn't have any type of fencing or barrier to prevent somebody from going over, that if they made it to the top of this reverse runoff. So we showed that they were aware that without having those three things, that there was a risk that somebody would go off the back of the ski ramp and could cause injury,
Why weren't those three things in place? It seemed like, was there some type of a shift change or something?
Well, no. So what happened? So the defense to the case was, in between each run, they regroom the hill. The purpose of regrooming actually slows the hill down, okay? And their argument was, before the 5 p.m. time slot, which my client was attending, and again, our accident occurred at 5:15, so within 15 minutes of them just opening up a freshly groomed run, they said, we groomed it. We send employees down to test to make sure it's not too fast, because if it is, then we'll put out these deceleration mats. And as far as they were concerned, there was no need for any type of barrier because nobody ever breaches, the top of the embankment. Again, getting back to my opening and using those standard operating procedures, there's nothing in the standard operating procedures that talks about any of the employees doing this, quote, test run, to test to make sure the hill was soft. And again, back to your earlier question about using things that counsel's saying, defense counsel kept telling you, somebody went down the hill, it's our policy, it's our procedure, it's this, it's that. And we just kept pounding away that every witness they put up, who's the individual who did the testing? Well, I don't know, but somebody did it. There was an incident report that listed 8 different employees, and we went through and we showed, like, this employee was here, this employee was here, this employee was here. There were 2 employees who couldn't be accounted for, 2 employees who had left before our incidents. We're like, where are they? Then we used other people's statements to say, this is the most important thing, identifying who rode down and tested this and who was working at the bottom of the hill. Where are they? Why isn't that documented in any of the witness statements from the employees or the incident reports? And if you're saying it's these 2 other people who we can't account for, where are their witness statements? Then, like, little things that didn't make sense. And I don't know how you do things, Brendan, but I rely so heavily on, believe it or not, my staff and my family, because we're trained as lawyers. We think like lawyers. We make legal arguments. Our jurors generally aren't lawyers, So I love asking, the person in the mailroom, my secretary, a paralegal, our receptionist, hey, what do you think of this? Because more likely than not, at least in my opinion, that's probably going to be closer to what the jurors are going to be thinking than what me sitting around with 5 other attorneys, are going to think is the case, because we're going to look at the legal issues.
Right.
And so one of the issues that my wife helped crystallize for me was why they kept talking about the fact that there were people stationed at the bottom. I was like, well, the one guy who was the manager was back at the lodge and said at some point he looks out and he sees a woman at the back of the hill, and he's not sure if she's making snow angels or if she's injured on the back of the hill. So he radios to a guy who's about 500 feet away at that guideline sign, and says, go check it out. If you have people working at the bottom of the ramp and you see somebody somehow got past you, flew over the back, wouldn't you think that one of those workers would have just simply run around the back of the hill and checked on the person?
Yeah.
Nobody did that, that would be the person or the workers closest to it. And that never happened. There's no report of that happening, so we were able to use that why are you radioing this person and why didn't anybody else go there? Again, these are all things to show the lies that even though they're saying there's somebody tested the hill, there's people at the bottoms, they couldn't produce any proof of it. And then we were very fortunate, and again, back to the point of having good clients, we had 2 witnesses, 2 other parents of families who were there, who came in and testified. The one woman was just the sweetest person ever. I mean, she essentially started crying on the stand because when my client Lauren went down, there were 3 lanes. My client was in the far left lane. This woman Jenna was in the middle lane. She went down. She saw my client go flying off. She got off her tube. She ran around like what you would hope one of the workers, if they were there at the bottom, would have done,
right,
to check on her. My client, when she came down, bit her lip, so she had blood coming out of her mouth. She was just laying there. She couldn't move. There were some other people there. And this woman, Jenna, her first thought was, oh my God, she went and grabbed my client's kids, because she didn't want them to see their mother in that condition.
Oh, yeah.
And then she starts talking about knowing that my client had to have surgery, how all the friends, they started this food train to bring food to the family while she was in the hospital. When she got home, how they're making arrangements from all their friends, transporting their kids to the football, the dance. She's talking about how she had to rhinestone my client's daughter's costume for the next, competition because my client couldn't do it. And Brendan, I didn't have to say anything. Nobody had to say anything about my people, but you knew the quality of my people just from those examples. You know what I mean? And then we also had another gentleman. So I got both a mother and a father because I wanted to have representation for both perspectives of the juror potentially. And his story was very similar. Nobody was around, how bad she was hurt, how everybody helped out. My client was on the stand for maybe 10 minutes at the end of the case because with using, we still did it old fashioned, believe it or not. Thank God for Jerry Hutton, my colleague, 75 years old, his first plaintiff's verdict ever. He was so excited.
Hey, good for Jerry. That's awesome.
Oh, it was great. But he went and he still got, the artwork that we had prepared, showing the injuries, showing the rods and all that stuff. And although we used them digitally for the depositions, he got the 11 by 17 boards, not too big, but not too small. You pass those suckers around to the jury, they were staring at them, they're looking at all this stuff, So the jury understood all that stuff. So by the time I put the plaintiff on, all the jury really wanted to do was say, yeah, she is a nice woman, I gave her like 10 minutes. I didn't cover anything that all the other witnesses has covered. I didn't want to waste their time. And, because of those independent witnesses talking about the type of person and type of family they were and what she went through and what she couldn't do and how they helped out, I believe that was a big driver as to the eventual verdict. And like I said, it was great because my clients didn't really have to say anything about what they went through. They heard it all. She just talked about what she couldn't do real quick. And she was a very strong woman who really downplayed her injuries, She was released, like I said, after 4 months with no physical restrictions, but she complained a lot about the ongoing neck complaints, and she was still taking an anti-inflammatory or a muscle relaxant, and she would take Tylenol a couple times a week. But her biggest complaint was, ongoing neck issues.
Yeah, it just seems like the quality and credibility of the people that they were surrounded by sort of speaks to her quality and credibility, right? Without having to,
right.
beat the jury in the head.
And it was such a dichotomy between here's what people are saying about my clients, and then you have the defendants making all these representations about all these not events that they can't support and they didn't provide us the discovery with, saying that somebody tested the hill but they can't identify it, saying that people were at the bottom of the hill but they couldn't do that. When they were asked about, well, how do you determine when to put out these deceleration mats, there really is no policy and procedure. It's kind of like, if I decide I want to do it, I do it. And then one of the best parts was their expert was, in my opinion, just horrific. He was there the entire trial, sitting there. And if I had to guess, this is just my speculation, but I think some of the testimony that was produced was was come up with during nighttime sessions with the expert to know how to try and frame some things, if you know what I mean, when testimony was coming. But I'm just going to tell you 2 quick things that were really funny about him. He was talking about, great policies and procedures, and this was such a safe park, and they went above and beyond, and this is one of the safest snow tubing parks ever. And I just started going through with him the same thing, like, what is their policy procedure that talks about testing the hill? Well, they don't have one, but they say they have one. Okay, well, who did you talk to that told you what the policy is? Well, the depositions. Yeah, the depositions just say they do it, but who did it, And just took them through all that stuff. And again, that's using the interrogatory. Like, this is the only book. Where's the book that talks about this, that, and all the things you're testifying about? And then I brought up the fact that it was very kind of him to only offer one of his opinions at trial during his direct examination, but the real fact was that in his report he offered 15 opinions, and 14 of them were to blame my client for her comparative negligence, her reckless conduct, her assumption of the risk. And one of the things that was just, I don't know about you, Brendan, I'm sorry I'm deviating, but I don't want my expert to be my advocate. I
Sure.
want,
Right.
if I've got a crap case, I want to know it and get rid of it.
Yeah. Right.
If I got a good case, great. But one of the things this guy said was that my client lacked common sense because she rode down the hill seated. So I said, isn't that one of your opinions? He's like, well, yes. I said, so you were hired to basically assassinate my client and blame her. He's like, well, that's kind of strong. He's like, but that's not the proper way to do it. I said, sir, I said, when you write in your report that my client lacks common sense, are you telling this jury that you were paying her a compliment? And of course, he looked like a moron in front of the jury. Didn't matter what he said at that point. So then I took him through, I put up in front of the jury his report that basically says my client lacks common sense. Then I went to the one document that Hidden Valley provided that specifically says you can sit or lie down. And I showed that and I read that. I said, so, and I pointed to the defense table. I said, so did Hidden Valley lack common sense when they implemented their policy that said my client could sit? And then the best part about it was, he touted himself as basically the authority in, snow tubing in the industry and all that stuff. And he has his little guideline book of 30 pages that is, the Bible, according to him. So I got him to marry that. And then I turned to the page in his book where it says, go down seated. And he has all pictures of people riding seated. And I was like, Mr. Stoddard, I hate to do this to you, but did you lack common sense when you wrote the Bible and said people can seat? So
What'd he say?
he made, I don't even care. I don't even know it. Everybody was laughing at that point, so it didn't really matter, if you know what I mean. But I mean,
Yeah.
obviously he had no credibility. But again, taking what the defense gives you and using it against them. And look, Brendan, you've gotten fantastic, verdicts. You just got a recent one. What I don't think people understand is you have to work really hard to get a good verdict. It's all the little minutiae. It's knowing your file. It's being able to pivot and take advantage of things. And the only way you can do that is if you really know, your file. My wife always yells at me because she'll ask me a question about a file from 5 years ago and I'll remember. And then she'll say, but do you remember what I wore to dinner Saturday? And I do, clothes?
100%. I'm like Mr. Magoo. I'm the most oblivious person about everything, but same thing. You asked me medical record, incident report from a case, a decade ago, and I can still remember it so clearly. But yeah. I think your point is so spot on, and I'm assuming that both of us almost have been doing it long enough where, what is sort of hard work, never, sort of stopping on turning over every stone and knowing every little shred of everything in the case. It almost becomes like second nature. Because I'm still I haven't done enough. There's more that I need to do. There's something that we're missing. And I oftentimes feel that way through trial. What am I missing? And it's not until sometimes you'll hear just gross misstatements by an expert on the other side or even defense counsel sometime. And it kind of makes you realize oh, I think I know this file a lot better than they do. And that's oftentimes where those gifts I'm talking about come from, is they just say something so stupid and off base that if you had just done a little further reading or research in the case, you would have known never to make that comment. But
well, I have to tell you, it's funny because, like I said, I've been doing this now for 35 years. And in all honesty, this is the first time I've been fortunate enough to try a case with a second share. I've had other people there helping me, handing me documents, working, back at the hotel at night, but nobody actually helping with the trial. I can't tell you enough of the hard work that Jerry put in, because it was his depositions. He did 99% of the discovery, and he got all of the witnesses to acknowledge that if the tube goes over the back, that somebody's going to get hurt, which we needed to establish the knowing, element of the recklessness, that you were aware that if you didn't stop somebody, if you didn't prevent them from going over, that they were going to suffer injury. And he did a ton of work. He also ended up doing both our medical expert and defense medical expert. And again, that allowed me to spend time just focusing all in on the liability and the layperson damages, if you will. I'm not sure if you try cases with, Greg over there, or if you guys go.
No, Greg and I mean, when I first started trying, probably, I don't know, my first many case, I tried all solo. And I haven't tried a straight solo case in a long time, and I don't want to, just
Right.
because if you're trying that case, as you just experienced with Jerry, with someone know and trust and can rely on, it just makes it so much less stressful, so much more enjoyable. You can kind of focus on the things that you're better on, and you're less distracted because then you don't have to worry about every single
Right.
witness. It's a lot. It's a lot to do it solo these days.
Yeah, it was a huge help. And like I said, I never, you know, I was never fortunate enough to be in a position to have that. So I am at Edgar's now. And like I said, I never want to have to try a case alone again.
Yeah, well, at Edgar's office, I'm sure you won't. There's a whole stable of great attorneys over in your office.
Yeah, we're very fortunate.
I was reading your the pretrial, and I don't know if this wound up being of any significance during the case, but it looked like in the pretrial there was an issue about like a missing statement or spoliation by somebody. Did that come in at all, or was that kept out?
So yeah, so when Jerry was taking the one guy's deposition, he was the assistant manager, but he was running the show on the day of the incident. And this gentleman, Bill Queer, during his deposition, Jerry asked him, like, well, did you give a statement? And he's like, oh, yeah, I gave a written statement. And we're like, well, we haven't been provided with that. And we showed him the statement of the manager, Mr. Riffle. And he's like, yeah, I did the exact same thing. It was a handwritten statement. I handed it into the snow patrol. They entered it into the computer. And we're like, well, where is it? And he's like, I don't know. So that was one of the issues we raised in the summary judgment motion as well. And then we requested the jury instruction. We filed, our motion limine that we would be entitled to that. We ultimately defense counsel ended up not objecting or withdrawing their objection to the spoliation charge. And that was one of the things with them starting to name witnesses. As they realized that was becoming a bigger and bigger issue, they wanted to bring in other people, supposedly somebody in the ski patrol who was going to explain that. They decided that his statement didn't say anything of importance, so that's why they got rid of it. We're like, well, again, why didn't you list these people, 2 years earlier? So we actually got the court to agree to strike the witness that they wanted to call in to come up with this fabricated story. I don't think the jury would have bought it anyway, but you know how it is. You fight over everything, So we were able to keep that out, and that was one of the things that we did. And again, that issue in and of itself, I think, allowed the reckless issue to go to the jury because there's a case that Jerry would tell you, I don't have it right in front of me, that in and of itself was enough for a jury to decide if they thought that evidence would have been sufficient to show the recklessness, the jury could hang its hat on that. I then used that statement to juxtapose with the one gentleman I told you, the guy Riffle, who was the manager. He was just recovering from COVID, but he stopped by on this day. And he was the one who radioed to say, hey, he radioed to Bill Queer to say, go check on somebody. Well, as our client's being loaded into the ambulance, taken to Somerset Hospital, this guy, Riffle, just Alice in Wonderland makes up this fairy tale about what happens, about how, her and her group of people, when they were giving the safety talk, the guidelines and all, how her and her friends were saying they weren't following any of the instructions. They were going to purposely try and go over, the back of the thing. So I just started going sentence by sentence. I was like, you said you never talked to my client. Where did you get this information? Well, I think somebody may have said that. And I just went through line to line. I said, sir, didn't you make all this stuff up? And he kind of like just shrugged. He didn't answer the question. I said, so as my client's being loaded into an ambulance to then be life flighted, to go have rods put in her back, your first thought is, what lies can I develop to blame that woman? So when we were able to juxtapose that, then the missing statement, my argument was, why Mr. Queer's statement is missing? Maybe Mr. Queer's statement said, we didn't test the hill, we didn't put out deceleration mats, and nobody was at the bottom. I said, why else was his statement not around? And I think it was pretty easy for the jury.
And so was that in closing? Was that sort of the focus of because I was looking at the jury, the verdict slip, and it literally is, did they act reckless? It wasn't
right.
What we're normally used to on these.
No, and that's the only issue. So, again, we showed that they were all aware that if somebody went over the back, if they didn't put out these safety devices or take these steps to ensure that the hill wasn't too fast, that guests couldn't be stopped. I mean, our argument was, we're an invitee. You had an obligation to make sure that our client riding your snow tubing hill was brought to a safe stop at the bottom of the hill. And it was really nice because the Judge Rulo in Somerset actually let us do voir dire the way it's supposed to do. Like, we got to ask questions. And, obviously one of the big concerns was everybody out in Somerset County goes to Hidden Valley, right, or Seven Springs. I was like, ladies and gentlemen, in my voir dire, like, look, we understand that if you go snow tubing, you assume certain risks. You assume that you could fall off your tube. You understand that there could be a tree root underneath the snow that can't be seen. You understand that somebody could leave a lane and come into your lane. You understand when you get to the bottom, when you're walking off, somebody might come down the hill and hit you. Those are all things we understand, but nobody gets on a snow tube at the top of the hill and thinks they're going to go to the bottom and get launched off at the end and go flying through the air, So that, we were able to show that that's not what anybody does, and that killed their assumption of risk. We were able to get jurors to acknowledge it, like, okay, yeah, if my client had suffered the same injury doing a normal snow tubing run, we wouldn't have a case, but who goes to a children's party, which their policy was anybody over 5 years, or anybody over 4, so 5 or above, 5 to 90, you ride one size tube. 5-year-olds can't sit in it or drag their feet. They can't lay on their stomach and drag their feet. So all of their kind of BS guidelines don't apply to 90% of their guests, And nobody expects that you're going to go flying over the hill and end up getting hurt. We were able to counteract some of their stuff too, because our expert found some YouTube videos, like, where they weren't following any of the policies and procedures that they said. Like, one of the things they talked about was their warning signs to drag feet at the top. And then we got all these different YouTube videos from like a year before to like 5 days beforehand, where the workers at the top of the hill are hanging their backpacks over the signs to drag your feet, or they're leaning on them. They're sending people down where there are no workers at the bottom. And then the one video was great. You see a guy go flying down, and this guy was probably trying to do it, but you see him go flying down, goes down, hits the ramp, nobody at the bottom, goes flying. He actually clears the hill, and you just hear him yelling, "Oh shit!" And we got to play that to refute, and impeach their testimony that this never happens. They've never heard of it or seen it, all that stuff. And that was also like just devastating. But that gets back to my point. Defense counsel objects. There was a link to these YouTube videos, right, in our expert report, right? So he starts objecting when I start playing it. He's like, "We never had notice of this, blah, blah, blah." I'm like, did you click the link in the report you've had for a year? Well, no.
Yeah, what did you think those were?
The judge is like, the fact that you didn't click it, that's your problem. But again, to the point of like working hard, doing everything, knowing your case, they thought our expert's report was BS, and they got their expert. So they obviously didn't look into our expert's report or what information you had contained in here. But, I played that video time and time again. So once I played it the first time, every witness who got up, we watched this guy go flying over. Now, again, he didn't get hurt because he was on his stomach and he was trying, and he was, you get the impression from his dash cam and all that, or his head cam, that he was probably a dude in his like early 30s who was doing his best to do what he did.
Yeah.
It showed the fact that it happens, and they should have known about it, and they should have taken steps to prevent it from happening.
Was assumption of the risk part of the verdict slip?
So no, because the way it works is assumption of the risk, the way the current law is it's a legal issue. So the judge, over our objection, allowed them to offer a bunch of evidence about her not dragging her feet, doing things, because he said he needed to develop a record to make the determination. Our argument was he didn't need that because, again, when you go into the lodge, they have all these blue signs that talk about this is a recreational activity, blah, blah, blah. You could get hurt. But again, all the warnings are the normal things one would think you're going to get hurt at. They're the exact same warnings that are on the waiver. So I'm like, Judge, nobody ever warned my client that she could go flying over the back, that they wouldn't have people stationed at the bottom. So how could it rise to the level of a knowing assumption if my client's never been apprised of these possibilities, But he let it in, and then he dismissed it right away. He's like, no, there's no assumption. So that issue never went to the jury. Again, I asked the judge to tell the jury to disregard that. He didn't do that, but he just basically, the only charge to the jury was reckless, and he basically said that negligence is not an issue. So he felt that by discussing those issues, there was no harm, no foul, that the jury heard those issues. I was more looking for an affirmative, like, hey, you've heard this. This isn't in the case. But he charged them on just reckless conduct. Defendants tried their hardest to argue that we had to show that Hidden Valley intended, to harm our client. It's much like, anytime you file for punitive damages, if they're like, well,
Yep.
the client didn't, it's evil intent doesn't mean you have to show somebody stand up, say, you know what? When Laura was at the top of the hill and I sent her down, I was sitting there going like, ha, 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 boy, we're going to really mess with her,
Yeah.
That's what the defense makes you think they have to show, which is not what the law is. You just have to show that they were aware, that their conduct was likely to result in injury. And despite that, they didn't take action to prevent it. So about a month before trial, there was a recent case that came out. The Superior Court recently withdrew the opinion, and now it's going to be heard en banc. But it was a follow-up to the H2O Monroe case about recklessness and allegations. So we were able to amend our complaint to include a request for punitive damages, because we're like, Judge, there's no amendment to the facts. I mean, the case has been reckless, from day one. It's been reckless since you dismissed the negligence claim. So the judge granted our motion to allow us to also ask for punitive damages. Right before we were about to go do our closings, the judge sua sponte decided to dismiss our punitive claim.
Oh, why?
His argument was we didn't have any evidence of the value of Hidden Valley for a jury to use as, one of the elements for how do you determine punitive damages. We had told the judge, or we had requested the judge both before trial and, during the charge conference and throughout, that, this was a classic case of bifurcation. Let the jury decide. If they find recklessness, then if we have to impanel another jury, let us go do our discovery. As you know, under the court rules, we have to ask permission for punitive damages.
Yep.
I don't know about you, but I've never had a defendant not object to, whatever punitive discovery. Then they want to say, well, we should just provide you with basically a certified statement as to our net worth, and you don't get to do discovery. But it's like, give us time to do that, and then we come back and have another jury simply determine how much punitive damages. And look, if the jury didn't find in our favor, the issue's moot. But the judge just seemingly didn't want the case to go any longer because it was now Friday afternoon.
Yeah.
So sua sponte dismissed it. So this Friday, we have our motion for a new trial on the punitive damages issue only, and we have a case right on point that basically, if he doesn't, then the Superior Court will do it, because there was a case on the other side of the state where I think it was a police officer was making a claim against his insurance broker. The broker must have done something not so good, because the allegations were bad faith, fraud. It looked like the broker must have backdated or changed some documents. I'm assuming maybe for UIM coverage or something, and then intentional interference with a contractual relationship. The case got tried. The trial judge did the same thing, dismissed the punitive damages claim, and the jury came back and found the intentional conduct on the other things. In that case, the plaintiff filed a motion for a new trial. The trial judge said, hey, I guess I messed up. Recklessness is recklessness, right?
And you got recklessness. I mean, that was the first checkbox on your verdict slip. So
in that case, the judge then sent it back for a trial just on the punitive damages. Then the defendant appealed, and the Superior Court said, no, the judge screwed up, but the judge did the right thing by correcting his mistake, and you're stuck with the punitive award. So we have that motion Friday, and defense motion for a, to dismiss the verdict, the same as their motion for a directed verdict. So we're pretty comfortable about that. So, in addition to our verdict, I think we're going to be going back and getting the opportunity to potentially try a case on punitive damages only, which I can't imagine a more fun thing. Can you, Brendan? I mean,
no.
Telling the jury, hey, somebody else has said that they acted reckless. Somebody else has awarded your client X amount of money. All you have to do is decide how much, if any, you want to punish them for their reckless conduct. So that
shameless plug, Doug, but I on this very podcast, I did a couple shorter episodes on punitive arguments, both by Mark Lanier and Shane Inspector, that are potentially helpful. So maybe check those out. But I'm sure a wise, wily trial lawyer like yourself already has some good punitive arguments, and that's awesome. And hopefully you smack them, and we can bring you back to talk about the punitives verdict and what that was like to try.
It should be fun. I mean, right now I'm going to do my shameless plug. We got confirmation from the Somerset County Prothonotary because our verdict of $693,000 is the largest verdict ever in Somerset County, at least in the last 20 years.
Yeah.
And if I had to guess, they weren't giving away a lot more money before 20 years ago.
Yeah. What are the chances there's a higher one? Yeah, not long ago.
So, so we're kind of excited about that, and
that's great,
looking forward
man.
to finishing things up.
What was, out of curiosity, what was the offer? Was there any offer to settle, or was it just like no way because it's reckless?
Yeah, no. The defense was all along no. They called me the Friday before, so we started the Tuesday after the holiday, on September 2nd. Friday afternoon, defense counsel called and said, hey, now that, the motions in limine have been ruled on, now that we know what's going on, do you have a number? And I don't know, you probably heard of Ed Balzerini.
Oh, sure, yeah.
So Jerry's like, ask him if he wants the standard number or the Balzerini number. So I gave defense counsel the Balzerini number of 350. He said, okay, I'll call you over the weekend. Crickets. We show up Tuesday. The judge is like, any attempt at settlement? It was like as if there was never even an offer, which was somewhat disappointed at that point because,
yeah,
so, but hey, look, my client ended up with almost double that amount, and with my delay damages, I'm up to $820,000, and now I'm going to go get my punitives. So
that's awesome.
I guess maybe 350 wouldn't have been so bad if they had settled for that before suit.
Well, that's an amazing outcome, Doug. Very cool case. A lot of hurdles to overcome. You shared a lot of sage trial lawyer advice today for young and seasoned trial lawyers. So I appreciate you coming on and doing this.
If I could just say one last thing, Brendan.
Please.
The judge, and he was a very good guy, but he wanted nothing more than to dismiss our case. He just, every time, like when I called one of the defendant employees in my case in chief, 3 of them I played video deposition clips from, but one I called in my case in chief. Defense counsel then says, well, Judge, he's here. I'm going to ask him my questions. Now, that's not appropriate. The judge is like, well, he's here. And again, these are the things that the real life trying a case, Brendan, which none of the people who've never really tried a case and are just trying to follow some civil procedure case or whatever, the judges are going to do what they want. But then the judge starts saying, but counsel, if you offer affirmative evidence, I'm not going to be able to rule on your motion to dismiss because you will have entered evidence. And he said it 5 or 6 times. I'm like basically pleading with defense counsel, don't do this because then I can't dismiss the case.
Oh my goodness.
The judge at the end said, we've never had a case go, come this far. There's one other verdict, but it was a defense verdict for gross negligence. He said, I don't know how you guys got this case here, but you did. And at the end, he's like, I can't believe that you got the verdict here against Hidden Valley. And like I said, he was neutral, I'll say, but he kind of leaned towards one side, if you know what I mean. So my advice is simply to anybody trying a case, he would sit there and say, I understand, and I'd just make sure you get things on the record. You got to protect yourself. Don't be afraid. Let the judge yell at you and say, I've already ruled on that, counsel. Why do you keep talking? I keep talking because I want to make sure if I lose this thing and I have to go up, nobody's going to argue that I waived everything. And again, I'm sure you know that, but I don't care if the judge likes me, doesn't like me. I'm going to protect the record for my client to make sure I'm not committing malpractice and to make sure that if things go to the next level, you've done what you got to do. And just people need to understand that as well. So
no, I honestly, I probably don't. I don't oftentimes do as good of a job because I'm so worried about trying to get the verdict, and you never know what ruling is going to be, that you need from that judge, whether it's on the jury charge or whatever happens. And I mean, for any trial lawyer, that's a really tough spot to be in when, and it's not like the judge is a bad person, but they just have their particular viewpoint and they kind of see the case a certain way, and you're stuck trying to overcome their confirmation bias, which is hurting you. And you've got to speak up and you got to create the record you just talked about, but it's not easy to do. It's a very awkward, uncomfortable spot to be in.
And from a psychological point of view, it sucks when you're walking back to defense table, from a sidebar that you lost. And when you lose pretty much every objection, you're just sitting there saying, do I even know what I'm doing here? Is it me? But when you get the verdict, you sit there and say, thank God all those rulings went against me, because what are they going to appeal now?
That is the silver lining. If you're losing them, it's like, well, at least we'll be able to hold the appeal if we'll somehow victorious. But no, good for you, man, and love to hear it. Super tough case, great outcome, and I hope the punitives go your direction as well.
Well, thank you very much. Thank you for your time, and congratulations on your recent verdict as well, man. You killed it.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.